我哋開會。
It's time to start the meeting. We've also formed a quorum, so let's start. Item 1 on the agenda of the panel on commerce and industry. Minutes of the meeting held on the 20th of January has been sent out to members. We haven't received any proposed amendments. Can we confirm the minutes? All right. Thank you. Item 2, information paper issued since the last meeting. The administration sent us a paper on Hong Kong Shenzhen cooperation meeting. That's contained in paper CB bracket 1 595/14 to 15 bracket 01. Item 3, date of next meeting and items for discussion. The April meeting will be held on the 21st of the month at 2:30 p.m. a Tuesday, covering 2 items. First of all, proposed legislative changes to the Patents Ordinance, which is item 1 on the list of outstanding items for discussion, to be followed by the latest developments of the Hong Kong Science and Technology Parks Corporation. Second item on the list, Dr. Zhang, would you like to propose a third item? Yes. For the beauty services industry in Hong Kong, I think last time there was a brief discussion about the industry. I just wonder whether we can also visit this topic. Yes, of course, some may think that this should be left in the hands of the Food and Health Bureau and the panel on health services. But when it comes to the industrialization of the beauty industry in Hong Kong, I think it should rightly be discussed by our panel. So can I propose it for the April agenda? Sure. In fact, it is on the list of outstanding items for discussion. So we can juggle it. So for the April meeting, there will be a third item as well. Mr. Chairman, 3 items, that means a longer meeting. I think we can divide the time appropriately. So 3 items, Patents Ordinance, latest developments of the Hong Kong STPC, as well as the promotion of the industrialization of the beauty industry in Hong Kong. So the clerk will liaise with the Bureau. Third item on the agenda, progress report on the implementation of the dedicated fund on branding, upgrading and domestic sales. I would like to welcome the representatives from the Bureau and the other related organization. We are all friends, so I'm not going to introduce you one by one. So I'll give the floor to Mr. Yong, who will walk us through the paper, and then I will open the floor to members. Thank you, Mr. Chairman. In fact, in our paper, we have already set out the progress on the implementation of the dedicated fund, like the projects approved, the publicity work, as well as the initial effectiveness of the projects. Let me briefly highlight the main points. In order to help our enterprises to capitalize on the opportunities arising from the National 12th Five-Year Plan, the government introduced in June 2012 the $1 billion BUD fund to assist enterprises in enhancing competitiveness and furthering business development in the mainland through developing brands, upgrading and restructuring operations, and promoting domestic sales in the mainland. We cover eligible enterprises and non-profit distributing organizations. We have already approved 267 applications and 44 projects under the 2 schemes. Under the enterprise support program, 96% of the successful applications came from SMEs. Among the 200 plus ESP projects, a lot of them are still in process. For the enterprises that have completed their projects, generally speaking, they feel that the brands have been upgraded, their costs have been lowered, and they're able to develop new products, and they're able to expand the channels for domestic sales. And then under the organization support program, many participating organizations think that the scheme has helped them to improve their branding and image, and they are more familiar with the rules and policies of the mainland. In the future, we're going to work through different channels to promote the dedicated fund, and will help the enterprises and organizations understand the mechanisms. We think that the schemes have been implemented smoothly. I'd like to pause here, Mr. Chairman. I'll be happy to take questions from members and listen to members' views. Thank you. Thank you, Mr. Yong. The floor is open to you for questions. I'm not going to set a time limit because it appears that not too many members are interested in asking questions. So I'll just wait and see if we need to impose a time limit. Dr. N. Jiang. Thank you, Mr. Chairman. In the paper, if I may refer you to paragraph 6, it is said that 96% of the projects come from SMEs. So question for the Bureau, what about the remaining 4% of the projects? Are they from larger enterprises or what? Mr. Yong. Well, for the eligibility for application, the enterprise must be registered in Hong Kong, and the enterprise must operate in Hong Kong, so enterprises of any size may apply. We have said that 97% of the projects come from SMEs. In other words, the risks are from larger enterprises. On the other hand, if I may also ask a question, in paragraphs 3 and 4, you have mentioned that under the ESP, we have got 260 cases being withdrawn. 268 were withdrawn. Why was it so? Is it because the application procedures are too cumbersome, and so the enterprises would rather abandon their applications? P.S. Mr. Chairman, I'll try to answer, and then if necessary, I will invite Mr. Lam from the Hong Kong PC to supplement. We are already finished with 10 batches of applications. Altogether, we've received over 1,000 applications. Among them, 200 or so have been withdrawn. Maybe this is because the enterprises have found that the scope of their business may not tie in with that of the objectives of the scheme, and they think that maybe it's better for them to withdraw the applications on their own initiative. As far as the application procedures are concerned, we try our best to help the applicants to understand the procedures, and we've worked through different ways, seminars, briefings, or face-to-face interviews, so as to help the SMEs who come forward to apply to understand how to work through it, and we try to resolve the problems for them. For the details, I would like to defer to Mr. Lam from the Hong Kong PC. Thank you, Mr. Chairman. Among the applications withdrawn, but in fact, when they first put in an application, we'll try to understand the nature. For information supplied by the enterprises, sometimes it is quite a sort of a far cry from the nature of the program. When they become aware of it, they may want to withdraw the application for the time being and try to put in an application in the following batch. Or sometimes they cannot provide the information that we need, and so they withdraw. It's, after all, an internal decision. In other words, it's not the Bureau that is it is not the Bureau taking the initiative to reject the applications. No, Mr. Chairman. Dr. Jiang. For us who are manufacturers, for us who have an industrial background, of course we have a different perspective. For the government, you think you have done your job when the project has been completed, but for us, we'll be interested in knowing about the effectiveness. Of course, the Bureau has also briefly talked about the effectiveness. Can you not sort of highlight one or two examples so as to allow us to understand the projects more? Mr. Yong, among the 200 plus approved projects, about 20 of them have already completed their projects. We've also sounded out the enterprises. Basically, they have told us that the subvention from the dedicated fund has enhanced their competitiveness. Maybe I can cite two examples. For example, there was this food manufacturer. With the subvention from the dedicated fund, they were able to upgrade their facilities. They were able to improve their manufacturing technology. In other words, the quality, their products could be sent beyond the Pearl River Delta region. They could extend their sales network to the rest of the mainland, so it has helped with their sales. And as a result of the dedicated fund, they have been given assistance to take part in show and sales events on the mainland, and they're able to increase their product or brand name recognition.
香港比較有歷史嘅一個製造商。咁就佢係用一個 OEM 嘅呢個形式去生產嘅，即係用自己嘅呢個設備。咁透過呢一個專項基金嘅資助咧，佢哋呢個企業咧就係能夠即係發展佢自己嘅品牌。咁就即係亦都係開拓到佢呢個品牌嗰個未來嗰個路向咧，係可以將佢自己本身製造呢個品牌咧係進軍呢個內地嘅市場。咁亦都喺佢嗰個喺符合咗呢個專項基金其中一個宗旨，就係話幫助企業升級轉型呢度咧呢個企業亦都做得到嘅。咁當然啦，我哋喺呢200幾個得到批准嘅項目裏邊，而家完成咗只不過20零宗，即係大概係10%到。我哋亦都要睇睇剩翻嗰啲嗰個執行嗰個實施嘅情況點樣樣。我亦都好希望咧，剩翻啲項目個實施情況咧，都係好似我頭先我向大家匯報嗰樣。
We will, of course, have to monitor the situation to see that these funded enterprises really do enhance their performance in the domestic market. Mr. Chairman, concerning the dedicated fund information as supplied by the administration, in terms of monitoring as of October of last year, basically for the OSP had already 36 approved cases, and over 20 of them had already been reviewed and assessed. Now, of the approved projects all along, there had not been a survey or on-site inspection concerning the efficacy of the projects and also the effectiveness overall. I would like to know from the administration concerning the OSP, this is rather different from the Productivity Council's practice. Now, why is there these two different practices? What is the reason behind? Mr. Chair, thank you for the question. After I've provided the answer, perhaps Mr. Mack can continue to supplement on the OSP's operation. Well, actually, in our monitoring work, there is on-site investigation. First of all, we ask that each and every project hand in their interim report and the completion report, as well as audited financials. And the Productivity Council does conduct sampling on-site inspection. Are you saying that there is on-site inspection? Yes. That's right. That is for ESP. As for OSP, I will ask Mr. Mack to supplement. Thank you, Mr. Chair. For the OSP, the object of support. I'm sorry, can you speak into the microphone, please, Mr. Mack? Yes, we can now hear you. As for the OSP, the object of support are, for example, commercial or commerce associations which support the industry-wide competitiveness in the domestic market. For example, in software, for instance, a number of software developers in Hong Kong would participate in sales expos in the mainland, and with the Hong Kong model, and conduct exchange sessions and also matching, business matching sessions. So that is to say, these organizations or associations would bring on participants or entities within the industry to access the domestic market. Now, as for on-site inspection, we do not do that systematically, but rather our colleagues, let's say there are workshops organized in Hong Kong or seminars organized in Hong Kong, they will attend. I myself, for instance, would also attend, or where they are in these functions are organized to take place in the mainland, sometimes I would also attend. So I would know as to how they are doing. But on the other hand, it is unlike the ESP, which is more systematic in the inspection of the implementation of the projects by the enterprises. But basically, the measures that we have at present is sufficient to give us a feel as to the effectiveness of these organizations. Also, they have to hand in their progress reports, the expos or exhibitions that they organize. We would know from the information, the pamphlets that they hand out, the number of patrons that they have achieved, and also basically the response of their events and functions. Yes, we would do that. Apart from subjective assessment and looking at figures and data, do you have objective measures to assess the effectiveness of the program? Mr. Mack. Well, actually, we have to look at the projects on their own merits. For example, let's say there's a project where there are Hong Kong pavilions in 3 exhibitions in 3 different provinces in the mainland. And there would be a number of entities involved in that Hong Kong pavilion, and there will be a selection process for the Hong Kong entities, and then there will be invited business entities from the mainland for discussions and business matching. And in their progress report to us, they will have to very clearly specify the events that were in the original proposal, and the outcome of them, how many Hong Kong entities actually participated, how many people from the mainland or entities actually came to the pavilions, and also how many entities or enterprise or organization or companies which have, through the function, matched up with mainland businesses. But of course, this has to do with trade secrets, and some are willing to provide the information, some are less willing. So we will look at the proposals, and we will look at the implementation, and look at how much had actually been achieved, and then we will assess that. We will come up with a score as to whether it's a high achievement, mid achievement, or not. And in the future, if there are applications in the future, we will look at this past record in the assessment of new applications from similar entities. Yes, Mr. Mok? Yes, I have heard from the SMEs concerning the application for ESP. Some of them have experience in applying for ESP, or their friendly organizations have done so. And they told me that there are agencies which apply on their behalf for the ESP, and the fee is pretty steep. I've forgotten how much it is, but it is a big chunk or maybe 40% of less than half of the funding, but I cannot be sure. But it is, to my mind, very steep in terms of the fees that these agencies levy for filling in or helping to apply on behalf of the entities. Now, you also mentioned there that there can be consultants employed. Perhaps these consultants would provide for the proposal, but on the other hand, the implementation would also, the consultants would also participate in the implementation of the proposals, and thereby collecting an even higher fee. Now, I have heard from the market that there are these agencies or consultants which help with the process. Well, this may not be a bad thing, but on the other hand, this is after all public funding, and the SMEs indeed need to develop in the domestic market, and there are organizations and enterprises which are not familiar with the application process, how to fill out the forms, etc. And as a result, there are these agencies which have utilized this public fund and gained overly high benefits, if you will. My question is, how many applications actually use these consultants or agencies, and how many of them have this one-stop shop approach, which basically participate or help out in the proposal stage as well as the implementation stage, and what is the fees that they actually levy? And I do not have a lot of information. This is what I heard. What information do you have? Now, indeed, if this is a common practice, then perhaps the audit in the future will also look into this. If there is something that is problematic, say, for instance, a big chunk of the money actually goes to these agencies, how would you handle this? Now, this is a rather grave issue, isn't it? Well, I do not know, but I have heard from the SMEs that, and they've shown me name cards saying that, hey, these are the agencies which do the proposals on our behalf, and they're pretty steep with their fees. Well, perhaps I will ask Mr. Lam to explain the actual application process. But in general, our starting point is to facilitate business. And under reasonable circumstance, where acceptable, we will try to facilitate the SMEs in their application. And the basic would, of course, be the filling out of the form. As mentioned just now, we have done a lot of publicity work, and we have invited interested entities to go to the Productivity Council, and we have staff there who personally explain to them the procedure as well as the filling out of the form. The intent is really to simplify the procedure and to help out the enterprises. Now, there are certain requirements, of course, because after all, we are spending public money here. Now, for instance, the applicant can employ consultants in helping out with the proposal and the implementation. As for the specifics, Mr. Lam, please. Mr. Chair, there is a point I would like to respond to in the question, and that is concerning the consultants and the experience of the consultants. What is the objective of setting that out? When we planned the proposal at the point of LegCo discussion, it was discussed that there are certain enterprises which do not know how to come up with a comprehensive business plan in accessing the domestic market. They therefore want outside help, that is in the form of consultants. And it's permissible. However, at the point of implementation of the projects, we find that these examples are few and far between. Many of the applicants actually already have exposure, they already have knowledge as to how to implement, and therefore not too many of them actually use consultants. Many of the successful applicants, as mentioned, 96% are SMEs, and very often what they need is specialized help. For example, technical consultants, brand consultants, etc. They might need help there. And therefore, we do allow the successful applicants to use part of the funding for retaining consultants. Now, if you ask whether there is abuse or collecting overly high fees by the consultants, well, apart from the content and nature of the projects which we will look into, and the committee will also look into that, and also the budget, etc. In fact, there are fine breakdowns. For example, if certain items is labeled, let's say, consultancy fee, and it's a big amount of money, without specifying what it is for, we would not accept that just on the face of that. We will ask for a breakdown so that we know what the funds are actually for specifically. And another point, the approval is on reimbursement basis, and that is to say the receipts, invoices, etc. will have to be provided to the Secretariat and also from there to the Management Committee before there can actually disbursements of funds. So there is certain safeguards.
So it isn't so much about the consultants. Rather, maybe in the market there are companies that can help the applicants to put in a bid. Some SMEs may not be familiar with the procedures. They may want to resort to a third party to do the application work on their behalf. We can't help it, but maybe you need to pay attention to such a observation. Maybe they aren't really engaging a consultant, and I assume that you have really done your work. I'm not saying that you should drive out such agents, but at least you have to tell the SMEs that if they can really do it on their own, then it's better for the resources to be channeled to their own promotional work rather than setting aside part of it to the intermediaries, because they can't really add much value, and such intermediaries may just take advantage of the SMEs, thinking that by giving part of the funds to the intermediaries, it will still be a good arrangement. So if you have also observed such a phenomenon, just make sure that the application is easy to go through, and then it's better for the SMEs. Mr. Mack, if I may also supplement, I also took part in the vetting work of the ESP applications. In fact, we took great care in vetting the applications, like their budget proposed to run an exhibition, to participate in the exhibition, or to engage others for their services, or to buy equipment, etc. We do have a breakdown of the budget. So if in the budget there is an item for consultancy service, of course that can be done. Usually we'll take great care if it accounts for a large proportion, we'll find that it is problematic. So if there are intermediaries helping the SMEs to get the funding, and if the intermediary can take a large chunk out of the $500,000 granted, I don't think this will exist, because the fund will be on a reimbursable nature, so it is unlikely that this will happen. I agree very much with what members have said. That is, I think we should continue with the publicity. We should try to do more so that SMEs understand the schemes better. Just now, Mr. Lam and Mr. Mack have said that if they spot anything unreasonable in the vetting process, if it is found that it isn't quite in line with the objectives of the fund, then the vetting committee will single that out for discussion. Yes, I hope you will continue to pay attention to this, but I'm sure you will act with great care. Mr. Sin Chung Kai. It is a progress report, and we are told about the status quo. So we've been given the percentages as well as the amount of money given out. I won't go over the details. I think from time to time, the Director of Audit will carry out a value for money assessment of schemes like this. But before that, I think the Bureau should also evaluate the effectiveness of the projects. Just now, Mr. Young has said that you have made inquiries. You ask them questions, you get replies from them. Of course, it is one way to do it. But I don't think you will expect them to come back to say that they get your money, but then they find it not effective. So it's better to have the measurable criteria. Say they get funding from you, and then they take part in a series of activities. We may want to find out the increase in the volume of sales, the increase in the number of inquiries, or other sort of outcomes. I just wondered if your report can also cover such points. Now, it was launched in June 2012 with a value of $1 billion. So it has only been in existence for 2 years or more. You are going to accrue interest as well. So it will be in operation for quite some time. I just wonder whether you have some measurable criteria so as to be sure about the effectiveness of the projects. I wonder if you would cover this point as well, so that you can evaluate the performance of the applicants. Permanent Secretary, yes, will be happy to follow up on the members' suggestion. Of course, we have to emphasize one point as well. While we attach a lot of importance to the effectiveness of the BUD fund, and that's why among the 20 completed projects, we did ask the applicants as to their views, their feedback. But it's easy to find measurable criteria. The limit of the fund for each applicant will be $500,000. It means that the enterprise won't rely solely on this amount of money. The strategies of the enterprise and the macroeconomic environment would also have an impact on the success or otherwise of a project. Yes, we will look at the effectiveness of the fund, but at the same time, we are interested in the feedback from the enterprise as to whether we can identify measurable criteria. We'll go back to study the idea. You are still in the early stage of the fund. You have only implemented it for 2 years or so. Of course, you need to get the information from the enterprises. Other than asking them for subjective comments like whether it is good or not, I think you should find out whether you can get objective data, like a comparison between the so-called before and after performances. Assuming that the fund is popular, and then in 5 or 7 years down the road, you'll be entirely depleted and you want to come back to get an injection. So probably by then we'll ask you the same questions as well. So just want you to get prepared. This is Mr. Sin's proposal. Yes, I understand his point. We'll be happy to explore the feasibility. All right, thank you. Next, Dr. Low. Thank you, Mr. Chairman. We have got the representative who is at the front line to help with the upgrading and the branding, namely Mr. Lam from the Hong Kong PC. Yes, the fund hasn't been in existence for too long period of time, but is it possible for you to sort of draw some early conclusions as to what would make it and what would break it? Can you identify the major reasons or factors? For the Hong Kong Productivity Council, you have been helping the SMEs. Some of the measures are more visible. Say, for example, green production technologies. It's easy to measure the effectiveness. In the case of branding and upgrading, it may not be that concrete. And I want to ask Mr. Lam to comment on the fund. Mr. Lam. Before I answer the questions, the Hong Kong PC itself has this mission and vision to help the enterprises to improve upon their branding and carry out upgrading. Now, the Hong Kong PC, under the BUD fund, has this role of secretariat. Since the 1st of January 2013, we have decided to put in place a firewall. In other words, we don't help the approved applicants to carry out the work. But then I'll be happy to sort of draw some early conclusions about the projects. Now, for enterprises who have benefited from this fund, usually the enterprises are more mature. They have a well thought out scheme. They are more familiar with the mainland market. And so when they go to the mainland to upgrade their branding and upgrade their technologies, they know how to do it vis-a-vis their competitors. For the failures, say for example, an applicant may not even get the approval from us. In fact, we've seen that for some applicants, they are well versed in the local market. They may have wholesaling business in Hong Kong, wholesaling fruits and vegetables in Hong Kong. They are keen to tap into the mainland domestic sales market. But then they may come up with the design of a website. They think that it's easy to go to the mainland market, but in fact they are not aware of the fundamentals. That is, for the sale of fruit and vegetables on the mainland, you need to have a lot of approvals, you need to have a lot of tests to be done before you can do so. So sometimes an enterprise may be very keen, but then it may not be that familiar with the mainland regulations or policies, and that has posed a difficulty. Mr. Chairman, of course, the Hong Kong PC won't just play a role in this particular capacity. In fact, the Hong Kong PC has been helping with the branding and upgrading for a number of years. I think the Hong Kong PC can help the applying enterprises in the sense that even if the application is rejected, the applicant will be told about the reason of failure. the fund can promote branding and upgrading. Just now, members were interested in measuring the outcome. I think, after all, we are talking about public money, so we have to make sure that it is spent in a proper way. For enterprises which have been given the approval, I hope the enterprises I think it is of great assistance if we can help the enterprises to improve their branding and upgrade their technology. I think it's important to liaise more with the trade associations and the chambers of commerce because they have extensive networks and they understand the conditions of the relevant sectors. Individual enterprises may get it wrong, so I think when you promote the fund, you have to maintain close liaison with the relevant associations and organizations. Mr. Young, thank you. Mr. Low, Dr. Low, I'm sure this is what we have to do. This is the right direction for us to move forward. If I may also add a word, if an enterprise has its application thrown out, we will liaise with the applicant, identifying the inadequacies, and we hope that through this process, the enterprise is aware of the inadequacies, and then they can rectify it, and then they stand a higher chance of getting approval in the following rounds. As to the measurable criteria that the members have asked for, yes, we'll try to study the matter. As the member has rightly pointed out, this is public money, and therefore, in the approval process, in the vetting mechanism, we have to act with great care. And some SMEs have found that it has taken a bit too long a period of time to process the applications. We can't avoid it, but after all, our goal is to help the SMEs in getting the approval. Next, Mr. Lam. Thank you, Mr. Chairman. I am interested in the figures concerning the ESP. I would like to ask the government for clarification.
You mentioned that there have been 1,158 applications as of the end of last year, and it says here 268 applications subsequently withdrew by the enterprises, and 890 applications are left, of which 267 were approved. And this is exactly the same as the number of withdrawals, except for one. Now, I would like to think that the intention is all positive for the proposals, that is, that there is to be extension of business. I would like to know why were there these withdrawals. Was it because they were not able to come up to the levels of your requirements, or is it because of the procedures, or is it because they do not reach your requirements, or is it because of certain application procedures? Now, there is some 268 applications withdrawn, and I also note the successful rate is only 267 which were approved out of the many applications, and that is not very high. I'm sure these entities know what they're doing, that they know what their own qualifications are, that there have been prior communications with you so that they know what their chances are. So my question is, why are there only that many approvals? That is not that many. And why are there so many withdrawals? I mean, this is also not the situation of the ESP and the OSP having two sets of guidelines. I mean, why is it not the same for OSP success rate? Yes, can you please answer that again? Thank you, Mr. Lam, for the question. I think the main principle is that this is disbursement of public funds. And the other consideration is that we are to help SMEs. And between these two, we will have to find a balance. Concerning the application procedures, as mentioned just now, whether it is commercial boards or associations or whether these are businesses themselves, we can arrange for briefing seminars, face-to-face interviews or discussions with the entities concerned, and to help them fill in the forms and assist them in the procedures for application. I will ask Mr. Lam to explain the reasons why there were these withdrawals. Now, as I have mentioned just now, we have to be very cautious in our assessment, and the not very high success rate is because, after all, the public funds will have to be spent prudently. And also, after the initial assessment, the management committee will review each and every applicant. I chair that committee. We look into the capabilities of the entities, the objectives of the project, and whether it is well thought out, whether it does live up to our requirements. And some applications which were not up to par were refused in the end. And after that, we will go back and tell them as to where they fall short. And if they are able to improve on those, perhaps they can come back and have a higher chance of being successfully approved. Yes, perhaps Mr. Lam can go into the withdrawals cases a bit more. As mentioned just now, Mr. Chair, for certain enterprises, after they have raised their application, our secretariat would actually go through a preliminary round with them. And looking into the content of their proposal, we see that there are situations where it far falls short of what our requirements are. And we will explain to the enterprises, and the enterprises would think that perhaps, given the case, they should go back and think through it more and withdraw, because there is no limit as to how many times enterprises put up their proposals. And enterprises where they think that the chance of success is not that so high, they would voluntarily withdraw and perhaps come back again some other time. Now, in the approval process, we also see certain withdrawals, that is, cases which have been voluntarily withdrawn or refused, coming back for another round of application. As mentioned just now, where the cases have been refused, there will be explanation from our staff as to why, and we do welcome them in coming back again for applications. Mr. Chair, yes, the administration had explained that they have done everything that they could in their indications, their guidelines, and also assisting the enterprises in filling out the forms and formulating their proposals. I'm sure they have done that work. However, I still notice that the withdrawal rate is not low. And the refusal rate also is not high. If you say you have done everything, why is it that the applicants still withdraw? Let me leave alone how many are successful in their application, but at least a first step. I mean, how come so many of them withdraw? Is it because something is amiss in your publicity or your guidelines? I mean, if the next year there is a similar number coming out, that would not be good. I'm not saying that we spend the public money without being cautious. That is not true. But on the other hand, having a high successful rate does not mean that you are imprudent with your funds. there has to be a high success rate as well, so that the enterprises will have a high rate of being approved. I mean, if you have the fund and you do not have the success cases, then you say that, oh, it is because you have been prudent and cautious. Now, this does not stand. I mean, of course, you have to be fair and transparent and equitable. But on the other hand, you also have to be able to provide the assistance to enterprises that we want to assist and developing their business. And I do see this number, that is the number of withdrawals. It is high, and I can see that you have not been able to help many of the enterprises. But of course, we are not saying that we want to just shove the money to these enterprises regardless, but there should be a higher success rate. Otherwise, every year it's 10%, 20% success rate or around that, then perhaps we will just do away with this dedicated fund because it's not being utilized. Well, actually, the dedicated fund had been in running for 2.5 years, almost 3 years. Of course, we review the operation of the fund from time to time to see how we can make improvements. And now it has come to this point, and I think that it is really time to see how we can make improvements. Perhaps we should go back and look at the 200-something cases. What exactly was the nature and content of the applications, and see for these withdrawals whether we need to amend or adjust our publicity explanation so that the enterprises would understand more as to what we're looking for. That's the first point. We will go back to do that. As for the approval process, it is true that we have to be stringent, we have to be cautious, and in that sense, when the cases go to the project management committee, perhaps they can approach it from a broader perspective in reviewing and assessing the merits of the projects. I can bring this view back to the members of the management committee for their consideration. We all agree that this program is to be well used and that there are real benefits gained in extending into the domestic market. Yes, we will study the program again with these from these angles. Now, I've asked a question just now when you were not in the room. There have not been any refused cases. 267 or 268 cases were withdrawn, voluntarily withdrawn. No, as of the end of last year, there have been 1,158 applications, 268 applications subsequently withdrew, and there were 890 applications which were left, of which 267 were approved, which means the rest of them were actually refused. That is true. Emily Lau. Mr. Chair, I agree with Mr. Lam in saying that the administration should design the guidelines and procedures so that they are easily understood by the commercial sector. If we look at Asian examples and European examples, their governments do support the SMEs because it is highly competitive in the commercial world and they need assistance. But what needs to be done is to be fair rather than to be partial. Now, Mr. Chair, when I was on this panel, the business never did like the government. They feel that the government was against them, especially the civil servants. They are so afraid of transferring benefits to the businesses, and therefore they tried to be very cautious and careful. Of course, I want you to be impartial, but on the other hand, if it is right, then go get on with it. help those businesses. As I have mentioned time and again, we want Hong Kong to have a good commercial environment to attract local and overseas investments and conduct businesses. Only then can we have increased employment for the Hong Kong people. Well, perhaps the Secretary would say, look at our very low unemployment rate. But, you know, a lot of the young people are quite at a loss. Some of them are unemployed. Now, if you can help the commercial sector and help the Hong Kong society, and I've talked about this time and again, in paragraph 11 of your paper, you have mentioned that it is not a situation where the enterprises all go into the domestic market and do not benefit Hong Kong. That is not the case. But are you just talking about these 330 new jobs created in Hong Kong, or what else can they bring back to Hong Kong in terms of benefit? Our city, how can we benefit from these projects? I have asked you before to write about these more in your papers. Well, some people say that these enterprises actually access a domestic market. It's not about Hong Kong. But what I want you to show is that it is a win-win situation. I mean, if you can describe how Hong Kong benefits. Mr. Chair, I very much agree with members here. The objective is to help with the development of industry and commerce and to assist in the extension of businesses and extend the scope of development for them in the domestic market is part and parcel of the scheme. And we'll be very happy to consider any room for review and improvement. Now, as for the win-win situation, we are also very happy in our future publicity to put more emphasis on that. So overall speaking, for this dedicated fund, what we want it to be is that it is a real support for Hong Kong enterprises in extending into the domestic market. The honourable members' views on the fund, I have heard them very clearly, and in our way forward considerations, I will take them into account. Mr. Chair, perhaps the Secretary can tell us about the difficulties that they have met in the operation of the fund. Mr. Chair, for the assisted enterprises, in our discussions with them, they feel that the the dedicated fund is beneficial to them.
And as I have said, the BUD fund will only be part of the input for the operation on the mainland. There are also other factors at play. So the fund will be helpful, but then there is still a basket of other factors, and such factors have to be taken into account as a whole before we can understand whether they can succeed on the mainland. Well, I think there is a press conference by that man on that woman. Now, what is the basket of factors? Mr. Chairman, did you get my question? Yes, and I know that Mr. Mack would also like to supplement. Thank you, Mr. Chairman. Let me supplement because I took part, but I cannot be very systematic in what I'm going to say. For enterprises, when they come to apply for our subvention, enterprises aren't quite like the government. They are not used to itemizing everything and preparing a well-drafted plan. So that's their problem. Usually, when SMEs come forward for application, usually we ask them to come up with a comprehensive marketing plan. And usually SMEs are not familiar with such a requirement. On our website, we have a template assisting them in putting together such a marketing plan. I think for members who are in the business sector will understand that SMEs are not good at putting together a marketing plan. And secondly, in the course of application, since we are talking about the use of public money, we have very detailed guidelines. Say you may employ someone to do the marketing for you. And for each and every item, we have certain limits. You may need $1 million for the marketing, and you want to get half of it from us. So you may want to employ 80 people to do the job on the mainland. We have restrictions, and we won't allow that. And then if you want to hire a place to showcase the products on the mainland, and again, there will be restrictions as to how much money they can spend on it. So for SMEs, the very detailed guidelines may pose as a difficulty for them. So the Secretariat is trying its best to explain the matter to the SMEs. Say, for example, on the first application, the enterprise may fail, but then our Secretariat will explain to the enterprise as to how they can improve upon the application. Mr. Chairman, they are doing business. When you give them money, as long as they don't pocket it for their own good, then you should just give them the freedom. You are not a businessman, and yet you try to impose very strict rules. If they don't follow your rules, you try to persuade them to follow your rules. Yes, I know that you have to be very careful about public money, but still you need to be flexible. You should listen to them so as to make it successful. Now, you always think that your advice is best, and so your job is to persuade others to follow your rules. Permanent Secretary, yes, we agree that in the process, if we can be flexible, we'll try as much as possible to give flexibility to the enterprises. We won't be rigid, but as to how we can be more flexible at each and every step, it all depends on what comes out from the interview between the Secretariat and the enterprises. At the same time, the Secretariat has the plan to prepare a guidebook or a booklet setting out the experience of successful applicants and also the hints and such information, so that the interested enterprises will have some basic understanding before they actually put in an application. By 4:30, we must return to venue. We can't extend the meeting time, so we need to be more time conscious. Mr. Chung. Thank you, Mr. Chairman. Enterprises and organizations need a few years' time to complete the projects. I think not too many projects have already been completed. But then if we have a good case, and of course we know that if you go to the mainland, you can't expect results after spending $500,000 or even $1 million. Can we sort of review the 50-50 split so that the enterprises can pick up 30% of the bill instead of 50-50? Or can you not sort of increase the total sum of money given, so that if an enterprise would like to continue with their efforts, and if they run short of money, then they can be assisted by you? So whether the matching ratio can be enhanced, and whether the amount of money granted can be raised. Well, the half-half share, which is the current rule. We believe that it is at the right level. But Mr. Chung has made a suggestion to change it. We will study the proposal. In some cases, they're merely asking for $200,000 or $300,000 instead of $500,000, which is the upper limit. For the 50-50 split, we expect the enterprise to be committed as well, but we'll be happy to reconsider members' proposals. Mr. Chairman, I just wonder whether for completed projects, whether the projects are successful or not, I wonder if we have a chance to meet with the participating organizations or enterprises so that we can learn from them in person as to in what ways the BUD fund has been proved to be helpful. Second round, and thank you, Mr. Chairman. $1 billion for the organizations, just about $100 million have been spent. The same is true for the ESP as well. So there's still a lot of money left. The next time you come, can you give us more detailed information? Say, for example, other than telling us in what industries the applicants come from, you can also sort of break down the information. That is, how many applicants ask for help in branding and how many for upgrading and domestic sales. We are interested in such information because they can help us to decide whether the fund should be continued or whether the fund should be given further injection. So we need a lot of data to help us to make the decision. In Hong Kong, many entrepreneurs, many businessmen have told us that they would like to go to the mainland market, but then they're not familiar. So though the mainland market is attractive, they are also afraid. Now that we have got this dedicated fund, maybe once they have tried, it is very successful. But of course, there are other cases in which they fail after several attempts. Now, if someone can go to the mainland market, it means that the market will no longer just be one comprising of 7 million people. Instead, there will be 1.3 billion people. Even if you're only selling toothbrushes, it will mean a lot of business. So please give us more data so that we can understand in what way we can help the enterprises. And then we can continue with it. We have already overrun, so you have asked a very long question. Can it be done, Permanent Secretary? Yes, we'll be happy to revise the presentation the next time we come. We don't know when you will come back, so maybe you just supplement the information after the meeting. That takes us to the second item for discussion, and that's about the new set of Copyright Tribunal rules. We have Mr. David Wong, Deputy Secretary for Commerce and Economic Development, Ms. Tam, PAS, Ms. Lee, Deputy Director of Intellectual Property, as well as Ms. Jasmine Kun, Senior Solicitor. Take your time. I would like to welcome the team from the government. In December last year, the government came up with a proposal to provide for a new set of copyright tribunal rules. The paper was sent to members a long time ago. So if members haven't got it, our secretariat have made copies for you. So if you need one, please approach the staff to get a copy of the rules. So, Deputy Secretary, would you like to walk us through the paper? And then I'll open the floor to members for questions. Thank you, Mr. Chairman. Chair, as you have said, it was in last December that we sent the paper to you, CB bracket 1340/14 to 15 bracket 01. We started a 2-month consultation exercise to invite the stakeholders to comment on the draft rules for the Copyright Tribunal. Some members are interested in the consultation exercise, and therefore we have come to brief you on the consultation. Well, the consultation exercise has been completed, and we have come back with a new paper concerning the feedback or the response to the consultation exercise. First of all, Copyright Tribunal. It was set up under the Copyright Ordinance. It is a quasi organization, and it will cover certain disputes concerning copyright and also the licenses. Sections 173 and 233 set out the jurisdiction of the Copyright Tribunal as well as the categories of cases in which the tribunal has the right to adjudicate, like the licensing regime and also the royalties to be charged. Well, for the Copyright Tribunal, currently it is being sort of governed by certain rules. But we have noted that the existing rules are already outdated, and it is necessary to modernize and update the tribunal rules. Therefore, Section 174 says that, in fact, the Chief Justice can make rules, and therefore we have been consulting the public on the draft rules. In the year 2009, we started the work. During that year, there was a public consultation exercise to ask the stakeholders to comment on the drafting approach and the direction. After we have when we prepared the draft rules, we took into account the consultation exercise in the year 2009, as well as the latest dispute resolution practices and development. In particular, development in arbitration, and we have also come up with the arbitration ordinance, and we have also taken into account the developments overseas. And then there's the background of our December consultation exercise. So a number of principles have been borne in mind. First of all, we have taken into account the civil justice reform principles. They have become the fundamental value of our tribunal. We would like to be cost-effective, and we want to be reasonably practicable in raising the efficiency and effectiveness. And we have also got the active case management. And thirdly, we promote the use of alternative dispute resolution, say, for example, reconciliation, etc. And in fact, for the various applications, we would like to standardize the procedures as well as the forms so as to facilitate the users. And lastly, we think that it should be a set of self-contained rules instead of having to make cross-references to other laws and regulations like the arbitration ordinance. So it is sort of a standalone set of rules. So it is easy, it is flexible, it can assist the tribunal in disposing the cases expeditiously, and we can help to resolve the disputes. So for the consultation for the draft rules, we are focusing on the procedures rather than the nature of the work of the tribunal. We completed the 2-month consultation exercise. 6 submissions have been received, some from the professional bodies, others from the licensees and the licensing bodies.
And the tribunal's members have also voiced their views. And overall speaking, the procedures and the stipulations are more modernized in keeping with the time. And also the principle of civil justice reform is they have also found favor. There is a consensus, and that is the draft rules should also have contain an effective mechanism for conflict resolution. And also there have been certain responses which were outside of the scope of the current consultation. As for the way forward, we have just concluded our consultation. We are considering the views. Where appropriate, we will be engaging the professional bodies and stakeholders to clarify their comments. And after that, we will be fine-tuning our draft rules. And where ready, they will be submitted to the Chief Justice for consideration, because after all, it is the Chief Justice who will be making these new copyright tribunal rules pursuant to Section 174(1) of the Copyright Ordinance. And after that, we would want to, within the present legislative year, that is within 2015 to 16, submit to the LegCo for negative fitting. So this will be the background of the consultation, what we have done, the results as they stand now, and the way forward. And we would like to invite questions from members. Now, because there are not that many members who would want to ask questions, there is no time limit. Would you please grasp the opportunity? Mr. Chair, I know in coming up with these draft rules, the administration had consulted the society, the Law Society. And I also see in the appendix there are certain responses from the Law Society. And I'm sure the administration had dealt with many of them. What I would like to know is whether there are indeed responses from the Law Society which the administration had not been able to handle or need more time. Can you give me a list of those which are still outstanding or you find difficult? Yes, Ms. Tam. Concerning Mr. Kwok's question, yes, indeed, we have exchanged views with the Law Society, and they have raised certain questions concerning drafting. They have certain suggestions and other queries. For instance, in the present version, what exactly is the meaning? They have sought clarification, and we have followed up with them. And also, we have tried to understand the reason behind their questions. And as of now, we are still collecting views, and we are considering the views at present. Where there are major issues, we will continue to liaise with them. I'm looking at the appendix with the comments listed out. Most of them have been dealt with. Is that true? Well, we are still looking at the comments from the Law Society and other organizations and persons, and we will collate them. But we see that a lot of the comments from the Law Society is on the drafting, perhaps to make the rules more clear to the reader. And where possible, we would want to address these concerns of them and to optimize the drafting. Yes, we were willing to do so. Are you saying that there is still room for amendments? Yes, we will collate all the comments from the different parties, from parties and individuals, and then we will consider how we can improve on the draft. But of course, the draft will have to be sent to the Chief Justice or the final Court of Appeal for him to consider. Have you also consulted the Bar Association? The consultation is actually open, and in that midst, we have invited the Bar Association to comment. We have not yet received any response from the Bar Association. Oh. If that is the case, if you should receive comments from the Bar Association or further comments from the Law Society, will you come back again to this panel, or would you? Well, I think before confirmation of the final draft of the rules, even though this is negative vetting for the LegCo, but you will give us the final draft of the draft rules. Is it not the case? Mr. Chair, in the consultation, which stretches from December to February, which has just closed, we're looking at the comments. And as mentioned just now, the Law Society mainly comments on the procedural and the drafting aspects of the draft rules. We have sat down with the Law Society to understand their thinking and to see how we can optimize our draft rules. But basically, we do see eye to eye. And together with the other stakeholders, including the Law Society, we will want to improve on our draft. There may be amendments and changes, and we will come back to the panel with a final draft. Yes, and what about the Bar Association? Yes, whatever we can take into account during the drafting process, we will do so. Mr. Ma Fung Kwok. From the 9th of December to the 9th of February is a consultation period. It just so happened that it was the period of festivals, Christmas, New Year, Chinese New Year. And I see that there are 6 responses received so far, 6 written submissions. I have a few points to make. First of all, this is about the Copyright Tribunal rules consultation. I noticed that among the submissions, there are no users apart from one broadcast organization. The others are legal or law-related bodies, and some are royalties collecting entities, but there are very few payers of royalties and fees. Why is that? And also, does the industry understand the import of these rules? And it seems has the government done sufficient publicity in explaining to the industry? Or perhaps I should refer to the users. The users actually have a lot of views concerning the Copyright Tribunal's operation. And I have just noticed this agenda item. And I also observed that some of these affected or payers actually do not know how to raise their opinions. Now, I remember I was one of the first batch of tribunal members when the Copyright Tribunal was first set up. I sat for a few years, but there were no cases. In the end, because of overly high costs, we have not been able to set any precedent case. that had went through the Copyright Tribunal. I do not know in the past few years how many cases it's dealt with. Perhaps the government had already gave us that information. It's just that I have not paid attention. Now, the industry, now I correct myself, not industry, but users, again, users, they do not know how to raise comments on the Copyright Tribunal, or in fact, they do not know how to use a Copyright Tribunal. The moment they see the costs and procedures, they actually already will not avail themselves to the tribunal for any conflict resolution. And they feel that they are on the weak side vis-à-vis their counterparty. So my question is, why are they not raising their views concerning the rules? All right, you're asking two questions. One, why only 6 written submissions? And secondly, if you can respond to the question also concerning case precedents from the tribunal. Thank you, Mr. Ma, for the questions. For the consultation, it is open to the public, open to all in Hong Kong. The responses really had not been high, which is much like the 2009 situation. There was another round of consultation then, and the respondents were mostly within the latest batch of responses, law, society, and others. And we welcome all organizations and everybody in giving us views. Can it be, as Mr. Ma proffered, it is because of high costs that people do not avail themselves to the tribunal? Well, it is an chicken and egg situation. Why do we not go through the courts for the semi-judicial setup? The objective is to lower the transaction cost in conflict resolution. And for this round of reform, it is all the more so in terms of a big stride ahead in this direction. That is to say, for those that are actively management cases and trivial cases, through the present draft, we are able to weed out those so that the tribunal can be more effective, efficient, and also lower the costs so that it lives up to its objective of setup. Now, as for the number of cases, they are not that many. Perhaps, yes, Ms. Tam? Since the setup of the tribunal in 1997, there have been 16 cases dealt with by the Copyright Tribunal, of which 19, of which 15 have already been completed, and 4 are still ongoing. Of the 15 completed cases, basically, the complainant had withdrawn or agreed to stop or cease the procedures. Perhaps there had been settlement reached. So, in fact, the usage is really not that high. But as the Secretary had mentioned just now, the new draft rules is under the civil justice reform values and objectives. That is to say, to give the tribunal more flexibility and also more ambit in their handling of cases. And that is in the hope that the users can be assisted and the parties to the conflict can find resolution successfully. And Mr. Ma talked about the costs and procedures of the tribunal, whether they are too formidable. And we have built in the draft rules, the mechanism where appropriate or deemed desirable, that for certain points of conflict allow for other means of resolution, such as mediation. So that is to go through other means to more swiftly resolve issues. It is true, at present the number of cases dealt with is low. But if the draft rules are passed and adopted, we will have more publicity that we will take up for the users and also to the members of the tribunal to explain the rules and the new characteristics of the rules.
If I may follow up, you talked about 15 cases. 15 have been completed, 4 are still being handled. Among the 15 completed, I want to know how many was disposed of by an adjudication on the part of the tribunal, or whether some of them have been withdrawn. 11 cases didn't reach the final adjudication. In the course of it, through settlement or through alternative disposal methods, the cases were dealt with. In fact, in civil courts, the judge would encourage settlement agreement or working it out through alternative dispute resolution. You know that it is expensive. Even if in the case of a tribunal, the cost will be lower than in a full court. But then if we can encourage settlement or agreement, it is a way to sort out the matter. And in fact, the tribunal will also adopt this direction. We will set out explicitly that mediators should be encouraged to be engaged to help the parties to identify areas of agreement so that they don't have to fight it to the end when the tribunal will adjudicate in the case. So we're trying our best to reform the rules. Mr. Wong, let me be frank with you. I was once a member of the tribunal, though I never had experience of hearing a case. That's the crux of the matter. None of the cases actually went to the tribunal for adjudication. Perhaps it was just too expensive. It was just not affordable, and so there was a compromise. And as a result, the tribunal is such that the parties to the case feel that they're being compelled to settle the case. That may not be the most satisfactory outcome. I appreciate the government's effort to streamline the procedures and find other ways to drive down the cost. But at the same time, while I'm representing the constituency, the licensing bodies as well as the users are both my constituents. But then there are also other lay persons, and they have complained a lot. They think that the fees charged are unreasonable. I'm a lawmaker. I can't just think in terms of the interests of the sector. I have to strike a balance. I think by comparison, the users are vulnerable. So for the tribunal, it may be easier for the specialists, the professionals, but for the laypersons who are users of copyright, they may not be able to benefit from the mechanism. So has the government ever considered the impact on the users? I don't think the users get any help at all. Well, I think it is not a matter of relaxation. It is a matter of tightening up the rules. It's not a matter of helping them or not. I want to have a fair and reasonable mechanism. I think that's most important. Mr. Wong. Yes, I understand Mr. Ma's point. I think we need to look at the institution. Being fair and equal are the values of our legal system. When there is a dispute, that will work through the judiciary so as to resolve the dispute. Usually it takes place in a court, but under some circumstances, we believe that the court may not be the only way out, and so sometimes we have quasi-judicial organizations to deal with the disputes, and therefore under the copyright ordinance with the copyright tribunal. As I have said, it is important to lower the legal costs involved through active case management and through upholding the principles of civil justice reform. We try to avoid the very expensive legal procedures because justice may be sacrificed. Therefore, we would like to amend the rules so that we are moving in the right direction. And we hope that by resorting to alternative dispute resolution, we can still handle the case. As I have said, going to the court may not always be the best. So by having mediation, and in fact, the DOJ is advocating it in the areas of construction projects or marriage and marital cases. I think this is a way forward. Copyright is special because it is intangible. Some large companies may be the owners of copyright. I think this is a characteristic of the capitalist societies. We try to be fair and just, and in this way, people can use the copyright products. I think we can resort to mediation instead of going to the tribunal or going to a court. This is still in line with the spirit of the rule of law. And we can avoid the draconian cost. So mediation is good. I don't think I agree with you, Mr. Ma. That is, mediation means that it is not satisfactory, and it's better to have more cases going to the tribunal. Mr. Chairman, maybe you don't understand what I'm driving at. Perhaps I should elaborate. I have been fighting for the protection of copyright for my constituency. I have a history of 20 years in this area. It is good to have the copyright tribunal. You don't actually talk about the criteria for resorting to mediation. Like we may have non-profit making organizations. An organization like this may want to hold an event, and then it may want to use copyright works. It may be a concert, a performance, which is admission free, and then it is not easy to identify to whom the fees should be paid, and it becomes complicated. So for a lay person, for a lay organization, non-profit making, they are at a loss as to what to do. It is impossible to expect such an organization to seek redress. I think for the 15 cases that went to the tribunal, I think it's business against business, rather than having individuals taking an organization to the tribunal. And that's what I meant by being unsatisfactory. I think in your political party, I have received complaints from your political party about such matters. I try to sort of mediate, but then it's not easy because the law protects the copyright owner. So the copyright owner has a lot of powers. So I'm afraid that the balance has not been achieved. Now, for the new rules, yes, in some ways, you are improving upon the mechanism. Now, some members of the sector may not quite agree with me, but for any mechanism in this area, it should be sensible and reasonable. Chair, do you understand what I'm talking about? Yes. I think the Secretary has taken on board the view expressed by Mr. Ma. No, we don't just rely solely on dispute resolution. In the case of a public performance, at LCSD venues like the City Hall or the concert halls or community halls under the jurisdiction of the Home Affairs Bureau, I think the venue charge already covers the royalties if copyright works are involved. So in some way, to a certain extent, we are sort of helping out. I think you need to publicize your work so that people won't break the law unadmittedly. So if I may ask for your view, would you in principle support the government's proposal to provide for a new set of rules for the Copyright Tribunal in the form of negative vetting? Is it agreeable to you? In this case, the panel will say that we are in support of having a piece of subsidiary legislation subject to negative vetting. Thank you.
Yes, Ms. Lau, can you please stay behind? The Rajaratnam School of International Studies and the World Trade Organization in 2015, from the 19th of May to the 21st of May in Singapore, there will be a workshop on international trade of the RSISWTO parliamentarian. Now, because this is within the ambit of this committee, and the chairman had actually referred this invitation letter to us for consideration as to nominate the nomination of 2 LegCo members to attend the Singaporean workshop from the 19th of May to the 21st of May 2015. I would like to ask members. Now, the letter also mentions that the purpose of the workshop is to increase the participation and the abilities of members within the region in participating in these work and in reaching or facing the WTO future challenges and in negotiation issues concerning international trade. The workshop will be conducted in English. There will not be simultaneous interpretation, and the CP 1632/14/1507 paper had been circulated to members for perusal. The deadline for application or registration is next month. That's April 11th. Now, I would like to know from members whether we accept or do not accept the invitation, and for non-panel members whether they can or cannot participate. Who will foot the bill, Mr. Chair? Duty visit. Yes, the funding will come from duty visit. Where is it again? It will be held in Singapore. The dates 19th of May to the 21st of May. If we are all agreeable, then yes, we will send members to the workshop. And what if there are more than 2 members who are interested? Right. If there are more than 2 members who are, yes, do we pick lots? Yes, indeed, we pick lots. Yes, would the secretary please be louder? Don't just talk to the chairman. Yes, right. The secretary said pick lots, either that or we, the panel, can make the decision as to who goes. Now, what would you prefer? I think the parties should be represented and the gender, that is, man and woman, should both be represented. Right. We try to avoid both members coming from the same party. And if there are only 2 interested, then we can't help it if they come from the same party. And also, if there are men and women, let us have a man and a woman go. But of course, if it's only men interested, then there's no choice, or only women, there's no choice, right? Right. For members of the panel, do they have precedence? Do they have the first right? Is that the practice, Secretary? Well, not really. There's, in the sense that if the panel feels that you can open this up to other members, yes, I think that can be done. Yes, we can open it up rather than to give priority to members of this panel. Perhaps the Secretariat can consider this further. Yes, can we send out a notification concerning the participation in this workshop? And in the 2 lecture members who go will have to come back with a report. Right, that is the killer. If you say that, no one would be interested. Yes, the Secretariat will not support. If you say that, no one will register interest. Yes, we have to specify that. That is a requirement, isn't it? Yes, they will have to draft their own report after the workshop. No other business. We close the meeting here. Thank you.